All right, and as folks continue to log on, we wish you welcome. I'm Julia, a bookseller at Politics and Prose. We're live with Sasha Issenberg and Amy Walter, discussing The Engagement, America's quarter-century struggle over same-sex marriage. You can follow the link in the chat to purchase the book directly from us at Politics and Prose. If you have a question for our speakers, please use the Q&A feature found at the bottom of your screen. We'll try to get to everyone's questions in the last portion of the discussion, though we apologize in advance if we run short on time. Additionally, we're glad to offer closed captioning for this event via Zoom's auto captioning service. To enable captions, click the CC live transcript icon at the bottom of the screen. And before we get started, we do want to thank all of you out there for joining us. We're really grateful to our family of loyal customers who keep our business and our spirits afloat. It's my pleasure to introduce this incredible book. On June 26, 2015, the US Supreme Court ruled that state bans on gay marriage were unconstitutional, making same-sex unions legal across the United States. But the road to that momentous decision was much longer than many know. In this definitive account, Sasha Issenberg vividly guides us through same-sex marriage's unexpected path from the unimaginable to the inevitable. This richly detailed narrative follows the coast-to-coast conflict through courtrooms and war rooms, bedrooms and boardrooms, to shed light on every aspect of a political and legal controversy that divided Americans like no other. Following a cast of characters that includes those who sought their own right to wed, those who fought to protect their traditional definition of marriage, and those who changed their mind about it, The Engagement is certain to become a seminal book on the modern culture wars. And moderating this evening is Amy Walter, the national editor of the Cook Political Report, where she provides a weekly analysis of the issues, trends, and events that shape the political environment. She is also the host of WNYC's The Takeaway, Politics with Amy Walter, and a political analyst for the PBS NewsHour. On behalf of Politics and Prose, please join me in welcoming Sasha Issenberg and Amy Walter. Thank both of you.
Thank you.
Thanks, Julia. Well, this is really an honor for me, Sasha, to be hosting this or to be moderating this. It's Politics and Prose, of course, that is hosting this on the very first day of Gay Pride Month, so June 1st. And this is your official coming out of the book.
It is.
Correct?
Yes.
Yes. So happy coming out days in October, but this is it's a momentous time for you to be doing this. And as Julia pointed out in her opening, of course, it was in late June when the Supreme Court decision came out on marriage. So it all feels in Washington, feels very serendipitous. I just want to start by letting folks know, I know Sasha personally. I consider him a friend of mine. I also consider him one of really the most insightful chroniclers of American politics in the country. He is thoughtful, thorough. He takes things that are incredibly complex and seemingly dense and unapproachable and makes them very approachable. And I think, to me, this book does all of those things while also telling some great stories. It's a storytelling adventure, Sasha, because it's one of these things, especially for folks in our generation who lived through every minute of this process, to think, well, what could I possibly learn about a book for something that I actually lived through? This isn't like you writing about the 1930s or something like this. So I want to start with this, which you put up on Twitter today, a little thread about the book coming out today. And you said, I had this idea for a book when I was interviewing posters for your book, The Victory Lap, which I also, by the way, highly recommend. And they kept noting that they'd never seen opinions move as quickly on a single issue as it had on gay marriage. And no one could readily explain why. And Sasha, I do remember having a conversation with you probably around this time when you said, I'm thinking about writing this book on gay marriage. But here we are now, it's 10 years later, 750 plus pages later. Why did a book that you thought about writing in 2011 now take this much time? Walk us sort of through that process and and how, whether you were able to sort of make these decisions, or whether it was fate, and as the events were moving so quickly, that was making those decisions for you.
Yeah, thanks so much, Amy, and thanks to Politics and Prose for having me back. So, I had the idea in the summer of 2011, and as you mentioned, I was having these conversations with pollsters, and at the same time, the New York, I remember the Saturday night when the New York State Senate voted to pass the Marriage Equality Act, and Andrew Cuomo signed into law basically immediately. And I had this moment where CNN cut to a crowd outside of Stonewall in Greenwich Village, and it's a fairly small crowd, a couple dozen people milling about. But it was this desire to impose a sort of put this in a historical arc that was familiar to people. And I realized that I did not understand the historical arc of this marriage fight. And so that's when I had the idea. And it was only after, I remember the Monday morning after Biden went on Meet the Press and said that he supported the right for same-sex couples to marry. And then obviously that led to Obama announcing a change in his position 2 days later. I went to my agent that morning and I said, I think this is already moving more quickly than I'd expected when I first had this idea. We should jump on it. And so I started work in 2012. And then already by the end of that year, the Supreme Court had announced that they would hear 2 separate marriage cases. I did not expect, in what I thought would be the 2.5 years I was working on this book, that there would be a marriage case before the Supreme Court, let alone what ultimately became a national resolution of the marriage story. And so, one big part of the answer to your question is the news got out ahead of me. And, for a creative person, it is humbling to think the U.S. Supreme Court works more quickly than I do. But it was I think I 3 times had to redraw my contract just to put a new deadline, because there's a sort of shared goal in this process between me and my editors that we wanted this to be a complete and definitive account of this, and once it became clear that there would be a sort of legal resolution to this, there was a goal of waiting until I could sort of account for that whole narrative, not just to the Supreme Court, but whatever fallout or backlash followed it. And I thought there would be more of that, frankly. But and so the book took me ultimately 6 years to report and research and write, and then a combination of some sort of adventures in the publishing industry. It's quite hard to convince people to publish a 900-page book, and it was quite hard to get some people to be interested in publishing a book that was sort of about politics or the news that didn't have Donald Trump at the center of it for a couple of years. And then COVID delayed it. This was supposed to come out last June for the same Pride Month reasons, and what would have been the 5th anniversary for Obergefell, and then the pandemic got in the way. So about 2/3 of the delay was just that the scope of the book got bigger, but then obviously some sort of circumstances outside of my control as well.
Right. So it is that rare occasion where you're actually watching history get made and you can kind of see where it's headed, versus I'm going to end this book and maybe 5 years from now, 20 years from now, I'm going to have to go back and write,
I mean, I actually had a worry that things were moving so quickly that 6 months afterwards, things would change, and it wouldn't sort of render moot what I had written, but something else would come along and superseded it, or had a better sort of captured the moment better. And so it wasn't just, this last 5 years, it was this last 5 months after, that. And what you mean, having lived through this and covered most of it in some form, maybe you remember this, it was a real tug of war for years. And it it was not until that moment in 2011 where I thought, okay, the trajectory of how this ends is clear. I did not think that we were 4 years from this being the law of the land, but it was the first time that I saw that the trajectory would head in only one direction. And up until that point, I think it was a real open question as to, would this be the sort of, if you define the goal as nationwide marriage equality, will this take generations? Will this be something that, there's a real fear after Massachusetts legalized marriage in 2004, that there could be a constitutional amendment in Massachusetts, and this would be a short-lived experiment that existed only in one state for a few years? Maybe this is too grand an analogy, but like Reconstruction, ended. And then the other question would be, could we end up in a situation, which is what I sort of thought was most likely, would be some version where we are sort of on the death penalty, where we have a patchwork and like roughly half the states have the death penalty and roughly half the states don't have the death penalty. And every couple of years, one state moves from one column to the other or slightly changes how they do it. And that was something that was the most divisive social cultural issue in the US for a few years in the 1990s. And now we barely talk about it as a live political issue. And we're kind of fine with the idea that you could cross a state line and the laws change. And so I think all those things seemed possible when I started this. And I'm surprised that my book has a sort of the end that feels very settled.
Right.
Yeah.
Well, I want to get to that too. But before we do, I want to start with where the book starts, because again, having to decide where to start this must have also been quite the journey. And, you could have started in a million different places. You could have started in Vermont. You could have started with civil unions. You could have started, as you pointed out, with gay marriage in Massachusetts. Instead, you start and focus on somebody who, honestly, even if you've been following this closely, you probably don't know, a guy named Bill Woods, who is this sort of gadfly gay activist in Hawaii. So talk about why you start with this sort of inauspicious character to begin our story.
Yeah, so it became clear. So there have been a few lawsuits in the early 1970s, basically in the wake of Stonewall, where gay couples, individuals decided in this sort of boost of enthusiasm about pursuing gay rights in court, we're going to sue to get married. And there were a handful of these cases in state and federal court. None of them really went anywhere. A few of these people had lawyers. There were none of the gay, to the extent that there was a gay legal establishment, they didn't support them. Nobody had a real legal strategy. And by 1975, all of these cases had died out. And then, starting for the next 15 years, the gay political and legal movement becomes far more serious, far better resourced, and on one hand has the opportunity for incremental gains in sort of non-discrimination laws, equal protection laws, and is dealing with AIDS. And so nobody is going into court demanding marriage rights for 15 years. And there's a case in Hawaii which has been written about. It took a long time for people on the mainland to take stock of it, but it was pretty clear in the historical record that the Hawaii Supreme Court rules in the spring of 1993 in favor of 6 plaintiffs, 3 couples who had sued for the right to marry. It was the first time any court on earth had acknowledged that the fundamental right to marry could extend to same-sex couples. And the Defense of Marriage Act, which gets proposed in Congress in the spring of 1996, Bill Clinton signed into law that September, was very clearly the kind of response of the mainland political apparatus to this growing fear that basically couples would leave Hawaii with marriage licenses, come back and demand that other governments, both 49 other states and the federal government, recognize their marriage. And so that sort of history was established. Nobody had done a good job of sort of explaining how the Defense of Marriage Act actually got written. But the big question that sort of struck me about that Hawaii story was, how did this case start? Because the sort of very, to the extent that story had been told at the time in the 1990s or revisited, there was this kind of weird gap in this activist took these couples to the Honolulu office of the Hawaii Department of Public Health to request marriage licenses, but then he gave them to a lawyer who sued the state, and none of the gay groups wanted to help him. But like, why was he taking these couples in to begin with if he didn't have a legal strategy?
And there was no strategy really at all. There was no just sort of like, I need to do this. Right?
Yeah. And so this guy, Bill Woods, as you meant, gadfly is one way of putting it. I mean, he was basically, I think he was the gay activist in Honolulu for the 70s and 80s. And he was like, I think a lot of first generation activists in whatever community they're in, he was incredibly entrepreneurial and incredibly ambitious, and was very good about creating things, not always that good about maintaining them, very good at getting attention, and not always good at building relationships or alliances. And he was immensely successful. So, he founded the gay newspaper, he founded the gay community center, he founded gay discussion groups. I mean, so much of the early kind of LGBT infrastructure in Hawaii was because of Bill Woods. And I tell the story, which parts of which, will cause anybody who's had to be in any event planning context, probably some case of PTSD, but he ends up in this rivalry for control of a pride planning committee in Honolulu in 1989. And his nemeses are these two lesbian women who have recently launched a monthly gay and lesbian magazine, which is competing with his gay newspapers for advertisers. And he wants to have a parade. They just want to have a picnic and rally. They give him a subcommittee, but don't actually take his recommendations. And he decides he's going to start his own parade planning committee. So now he's trying through to do whatever he can to upstage this rival pride event. And so he asks a friend of his who's a chef to create an international food festival, and he gets the Royal Hawaiian Jazz Band to commit to play, and he enlists some local politicians to be the grand marshal of his parade, and he decides he's going to have a wedding, basically just like piling on spectacle. And he's not a lawyer, and he, it seems, misreads the Hawaii family law code and comes away with the misguided impression that possibly if these couples married, their marriages would have to be recognized by the state. And so he wants the state ACLU to back him up in this, and they want nothing to do with him because members of their board had fought with him over other issues. He is seen as a kind of like, pick your cliche, lone wolf, loose cannon, whatever. But they also don't want to say no to him because they know that if you end up in a sort of conflict with Bill Woods, he'll revel in the conflict and it won't be good for you. Picking an open fight for a group that considers itself a leader on sexual privacy issues with like the most prominent gay activists in the state is sort of bad PR. And so they just push him off for a year, trying to hope to get him past the Pride Month thing, thinking that he'll give up. And eventually he doesn't give up. And instead he says, I'm going to try to force the ACLU's hand by bringing these 3 couples in. And I'm going to get basically the entirety of the Honolulu press corps to document it, thinking it's going to force the ACLU to take this case. And the ACLU still doesn't take this case, and it gets handed to a lawyer the next January. And that's when you start to have a court record that people have tracked that sort of contours of. But it was really important for me to kind of figure out what the origins were, because I think that there is this desire, for people who've read about or lived through other sort of landmark pieces of civil rights litigation to assume that this is all very carefully plotted, test cases. You go out, you find the perfect plaintiff, you shop around for a venue. And if you've read the, history of what led to Brown v. Board, if you read, a lot of this sort of monumental legal history, there are often stories of how the lawyers very deliberately went about setting up these cases to end up with the result that they got. And what I sort of stumbled into when I was trying to understand, Bill Woods passed away in 2007 or 2008. I never met him, but I was able to sort of reconstruct through his papers what he was doing in that year. And it was just pretty clear there was no plan, no strategy. And he ended up basically having nothing to do with the case after it got handed to a lawyer named Dan Foley, who in a certain respect got very lucky with some things that happened on the Hawaii Supreme Court about a year and a half after he filed.
Well, it's such a great story. And it goes to sort of the heart of this, Sasha, which, to me is like a major theme of this book, which is sort of ambivalent civil rights, this fight, right? That there's ambivalence on the part of the gay community who hadn't picked this fight, but now it's in front of their plate when Hawaii puts their decision down. And these, as you pointed out, the sort of establishment gay groups who had been focused mostly on sort of incremental gains, on AIDS, on other issues, were like, wait, now we got to do marriage. What are we going to do about this? And then even opponents who were, not thinking that this is where their energy was going. So many of them, whether they're on the sort of traditional cultural issues, but it had been abortion and things like this. And as you go through the book, you also notice that the sort of struggle with the anti same-sex marriage side really having this divide and ambivalence over how far to take this. Should we oppose any sort of unions? Like, should we be against civil unions too? Or is this just about like marriage? So can you help us sort of understand that and talk about that ambivalence and how it really is so prominently displayed, over these last 25 years?
Yeah, and I think this is a broad critique I have of political journalism that, I think we're very good about writing about sort of two-sided issues that fall along kind of crossfire style or, across the aisle things. I think political journalism generally is rather poor in documenting conflict within what to outsiders seem like unified movements. I don't think people don't do a good job of documenting conflict among labor unions. We just write about the labor movement. We don't do a good job of looking at conflicts among evangelicals. We just say religious conservatives want X. And I think that sort of, one reason that this all seems very new to somebody who's both, in my case, researching it and to readers is that I think a lot of the coverage of this issue just sort of assumed that there were two sides of this issue at all times and never really got into the intramural conflicts, a lot of which were private. I mean, a lot of these groups don't have sort of interest in airing this stuff. So it's not just complacency on the part of journalists, and it starts in the 1980s when, as I suggest, there were no cases. Marriage was not a live issue to the extent that anybody was debating marriage in the 1980s. It was a relatively small group of, gay and lesbian lawyers, legal academics who debated this as an abstraction, but there was a sort of active debate over, is marriage worth pursuing? And there were, some of it was a sort of strategic tactical critique, which is we can get these incremental gains. Why are we, reaching for the gold ring or whatever? We're not going to win and we're just going to, embarrass ourselves trying. But then there's a real ideological debate, which is, it broke down largely on gender lines, to the extent that there was kind of LGBT family law in the 1980s, it was overwhelmingly focused on the needs of women. And so female lawyers representing, female clients who were almost universally in the situation of women who had been in heterosexual marriages, had children biologically with their husbands, come out of the closet, leave their marriage, and then are unable to secure rights to their own children in court, their biological children. And so to the extent that there was LGBT family law, it was focused on this question of children and adoption. And a lot of the lawyers were women who had gone to college and law school in the 60s, 70s, were shaped by sort of, second wave feminism. And they viewed marriage as this patriarchal heteronormative institution that had been basically created in their view to subjugate women. And their view was, why should the goal of gay and lesbian family law types be to be included in that? There was a lot of talk at the time about multiple families, that the objective of LGBT family law, to the extent they use that phrase, would be to kind of to aim for a legal regime where a wide variety of family structures were treated equally under the law. Single parents, parents of any gender combination, co-adoption, all this stuff would have sort of the same legal foundation. And at the same time, men in the gay community in the 80s were not focused on this idea of I created a child, but they were overwhelmingly focused on HIV and AIDS. I mean, there wasn't I don't think a woman who contracted AIDS through sex until 1989 or 1990. And so AIDS was overwhelmingly a problem for men in the gay community. And that led them to focus on concerns around death, which had not been a major part of sort of the gay agenda to the extent there was one earlier. And so all of a sudden you have men in this movement worried about things like hospital visitation, transferring property rights. I read about a case that goes to the New York Court of Appeals in 1989, where they ruled that two guys who lived in a Hell's Kitchen apartment together for 20 years. One of them dies, presumably of HIV. The other one is getting evicted, even though it's a rent-stabilized apartment, and the court rules that his longtime partner qualifies as a close family member under the rent stabilization law in New York. And so there's this real tension over, is marriage worth fighting for? And it's not settled. The thing that settles it is that period between the Hawaii decision in 1993 and the Defense of Marriage Act being written in 1996, that opponents of gay rights unify enough around this as this is the thing we are going to fight right now, that a gay rights movement that had been ambivalent, as you say, fractured, really divided on a deep level of principle about this, come together and decide our opponents are trying to stop us from getting it. We need to fight for it. And it is, it's not just that there's ambivalence. One of the things that come through the story is just sort of the unintended consequences of this at all times, where with things in retrospect that look like huge strategic errors. And I think this is one that, this has been this local fight in Hawaii that gets nationalized by gay marriage opponents in a way that at the time seemed to advantage them, and also gets, federalized in the sense that now it is a matter of federal statute. The only reason this came before the Supreme Court in 2013 in the first place was because the Defense of Marriage Act was written into the federal code. And had it not been, I assume that we would be in a state by state, there'd be no reason to bring this into federal court at any point. And that was ultimately something that in retrospect, it was religious conservatives who set themselves up for that ultimate failure.
We'll talk about the divide within the conservative movement, and also how this, it did not sort of sneak up on them. You write about the fact that as this, the first court decision in Hawaii came down, there was definitely alarm being sounded in the conservative movement, like we've got to start preparing for other states and other state courts to follow Hawaii's lead. And so preparing for this. But as we moved along through this process, you started to see those rifts occur about the right strategy and, sort of watching where the other one, as you do with any opponent, you're watching them zig and you're thinking, should I zag or should I zig with them? Where do I?
Yeah. And so this is an unusual, when we think about this sort of, again, in comparison to other civil rights movements or social movements, both sides were on offense and defense simultaneously on this issue. There was nobody trying to expand Jim Crow in 1955 or 60. And so you had times where there were, states where folks are trying in the courts or through the political process to legalize same-sex marriage, but you also had opponents who are trying to introduce either bans through statute or constitutional amendments at the same time. And so the strategic calculations are a lot different in terms of where you fight and where you don't. But it's a period between around the time of Massachusetts. So the Massachusetts court ultimately rules in November 2003. But what happens earlier that year is the Supreme Court in Lawrence v. Texas strikes down state bans on sodomy. And Scalia writes in his dissent, gay marriage is next. And that is, he writes it explicitly as a warning to conservatives, and he was incredibly prescient in seeing the arc of this. And that drives what had been a fairly small effort among conservative activists to push for a federal marriage amendment. It had been drafted in 2000, been introduced on the Hill in 2002, never got traction until Lawrence. And within a week, Bill Frist, who's the majority leader at the time, endorses it, which signals that it's going to get a real sort of push on the Hill. And all this is in anticipation of the expectation that Massachusetts is ultimately going to legalize same-sex marriage. And because of Massachusetts's state rules, it's going to be very difficult to beat that back through the political process after that's happened. And so the strategic question that conservatives face at that point is, there's like broad consensus among religious conservatives that pursuing a marriage amendment is really important. And people are already using real apocalyptic language that if we let this happen, it's going to be, 9/11, or it's going to be like really hyperbolic stuff. But the question is what should the amendment say? And so there's one debate, which is, should it just preclude state court or courts from interpreting any constitution to award marriage rights, acknowledging that if a state goes through, and this is, more of a proceduralist argument, that if a state goes through the political process to legalize same-sex marriage for its citizens, that conservatives should respect that as an exercise in a federalist spirit, exercise that as this is, laboratory of democracy, states should be able to do that. But we as conservatives are opposed to activist judges imposing this on the public. Ultimately, so that's one tension. And then the bigger tension is, do you write this to just ban marriage, same-sex, say basically that marriage in the United States shall only be between a man and a woman? Or do you write it to say any equivalent of marriage, which would be civil unions or a sort of robust domestic partnership, that none of the incidents or benefits of marriage shall be extended to same-sex couples in the United States? And the group that had been pushing this, trying to get the Bush White House to take this seriously in 2003, almost cracks up over this divide, because you have everybody recognizes that the politics of this are such that it's already a heavy lift, obviously, to pass a constitutional amendment. And it'll be impossible if this is a blanket ban on states recognizing same-sex couples. But you have kind of, absolutists within the movement saying, if we're not going to stand, Jerry Falwell, folks like that, who are saying we're not going to, most people don't have a great understanding of how Capitol Hill works. Arguing that we need to push for the kind of absolutist vision of this and we shouldn't compromise. And some of the inability to get the Bush White House on board is that throughout the fall of 2003, after the Massachusetts decision comes in, the conservative activists cannot agree among themselves what a constitutional amendment should say.
This is something I want to dive into, and I also want to make sure to put in a plug for folks when you have your questions. Again, it can be, obviously, Sasha has been deep in this for so many years, and there are so many great stories within this book that I think, any one of your questions could touch upon. So we talk about this sort of strategy, and it seems like for years, as you pointed out, like for conservative activists, what they had going for them was just public opinion, right? Like, you didn't need to do much more than that, is to say to, especially to politicians who are up for election, like, look at the data. It's not popular. If you support gay marriage or seem to be supporting it, you're going to lose. And so, right, we saw the tension within the Clinton White House over this. But then, as you said, like in your tweet today, it's almost like something flipped in 2011. Like, literally, you can look at the Gallup polling and you see it's like opposition, majorities opposed, right up until about 2011. And then that's where the tipping point is. And it flips to majority support, and then it just keeps going up. So, you see it going, through the late 80s, 60+% against. Now it's almost 70% or even more at this moment in time for. And at the same time, it's unclear what that, like, how that became a tipping point. And the one thing I want you to address is, it seemed like, yes, the writing looked like it was on the wall. Massachusetts, Barack Obama gets elected in 2008. It's like, okay, now we've really hit this like cultural moment, tipping point moment. And it's also the same year that the Proposition 8 amendment in California passes, which, you think if there's any state that would defeat an anti-gay marriage amendment in the year 2008, it would be the state of California. And millions and millions of dollars went in to defeat that amendment. Hollywood, all the big stars, I remember that, all wearing their like No on 8 tattoos and bumper stickers and all of that. And there was a real reckoning, it seems like, at that moment. So can you talk about, what the Proposition 8 moment was? And like everything in life, history is not a straight, direct line. It doesn't just go from like A to B. They just kept going up and up and up and winning. It was that you had this incredible setback at a time where it looked as if the corner was turned.
Yeah, so there had been before Proposition 8 about 35 states that had statewide ballot measures to ban same-sex marriage.
Right.
And in every one of those states, the anti-gay marriage side had succeeded. And there was, almost always a good rationale for the folks who'd been on the losing side of that fight as to why. They had fewer resources than their opponent. Public opinion was against them from the beginning. It was a fundamentally conservative state. The political establishment was arrayed against them. It was an off-year electorate with lower turnout, whatever. Like, there's always a good reason to explain why they kind of should have lost. In California was the first time that there was not that excuse. Not only is it a liberal state, it had already had marriage. I think a lot of people outside California don't fully appreciate what happened with Proposition 8 wasn't just preemptively banning a court from awarding marriage. It was for 5 months, this, couples had been getting married in California, about 20,000 of them, I think, under a state Supreme Court order. And this was not undoing their marriages, but taking away the right for people in the future. And I think to go back to your earlier question, or earlier part of the question, part of it is the status quo bias was often on the side of not doing this new and crazy thing. And in California, the status quo was that gay couples were getting married without obvious incident. And so that was a big deal. And the whole political establishment in California was opposed to Proposition 8. Not just Democratic electeds. Arnold Schwarzenegger, who's the governor, opposed it. So there was, when the gay marriage side lost that fight, they were shocked and they did not have a good explanation. And and they had all the money in the world. They had $45 million to spend. It was one of the most expensive ballot contests in American history at that point of any kind. And so that caused a real reckoning within the folks who were doing these campaigns about what did we do wrong. And there had never been that type of examination previously. And what you get out of it is a sort of new structure. There's a creation of a group called Freedom to Marry, or a relaunch of a group called Freedom to Marry, which all of a sudden becomes a kind of hub for all the political, legal strategy and research around this issue, which is a real different model from a kind of interest group. What you'd had before is a human rights campaign, the National Gay and Lesbian Task Force, which has a whole umbrella of issues that they care about, right? And so part of, you see HRC being split in 1996 over how hard to push back against Democrats who support DOMA, and they're weighing a lot of other interests. And I get it. Your goal is long-term relationships on the Hill, so the next time you go to get Ryan White Act funding renewed, that some moderate Republican or conservative Democrat takes your meeting and you could get through to them on this issue, right? That when you go to them to say that the Commerce Department should tally hate crimes statistics for gay and lesbian attacks and not just on race and gender, that people are responsive to that. And if we pick a fight, we're not going to win on marriage, we're just going to alienate those people. I get that, that's the institutional imperative. What Freedom to Marry did is it said, we are built for one goal, and that is marriage in the 50 states and the District of Columbia. We're going to put ourselves out of business as soon as that happens. We do not care about ending Don't Ask, Don't Tell. We do not care about a non-discrimination bill. We don't care about any of these other things. We're built for one goal, and that's really unusual, this sort of discrete policy objective. And luckily, there were a sort of circle of very wealthy kind of gay mega donors who had already taken to marriage as an issue. And they were ready to fund this. And Freedom to Marry coordinated a lot of research that kind of revisit a lot of the fundamental assumptions about how activists should talk about this issue, how they should organize their campaigns, and undermined a lot of the conventional wisdom about the best way to go about doing that.
That was one of my favorite
2010, 2011 that you see that those changes take effect.
Well, that's one of my favorite anecdotes in the book, was about how, it was through this research post Proposition 8 that they said, the Freedom to Marry folks said, we got to stop talking about this in sort of legalese, right? This is about, ability for gay couples to see each other in hospitals, all the tax benefits, all the legal rights, and make it about love and commitment. Right? Make this much more about love. And to me, it seems so obvious, right? Well, of course, personalize this issue, make this about human beings rather than about this legalese. But why did it take so long for that to happen. And I'm also wondering if you can weigh in on the fact that during this same time that marriage is not legal, there are still a lot of people gay couples getting married, right? And having ceremonies. And so talk about that as well.
Yeah. So some of it is just, it's legalistic because this movement, the political activity started in response to
with lawyers. Yeah.
And so the lawyers were often the ones sort of starting the campaigns and then adopting the, the political activists adopted the arguments that had been used in court, I think is a big part of it. But the other part of it is that to some extent by 2010 or 11, gay marriage campaigners were a victim of one of their successes, which is the success of civil unions. Civil unions, were never a goal. They are a lawsuit wins at the Vermont Supreme Court in December of 1999. The Vermont Supreme Court says it is unconstitutional to discriminate against gay and lesbian couples, but says to the legislature, you don't actually have to let them marry. You can find some other institution that gives them all the equal benefits of marriage, as long as, and so the legislature comes back with this sort of novel idea of civil unions, which is marriage under a different name. And at the time, that's obviously incredibly provocative in Vermont. Howard Dean wears a bulletproof vest as he runs for re-election because there's Vermont, a real, sense of fear. It's a more emotionally fraught political issue than anything else. But over the next decade, civil unions becomes a safe middle position. Basically every Democrat who's running for president in 2004 supports civil unions. Almost all the ones who are running in 2008, including Obama and Hillary Clinton, support civil unions. And by 2010, the folks who are doing opinion research on this basically split the country into three groups. There are about a third of the country that supports same-sex, maybe close to 40% who support same-sex marriage rights. You have about a third of the country who are just fundamentally anti-gay and oppose a lot of gay rights initiatives. I don't think it's really about marriage for them. It's about the fact that it's gay rights. And then you have what they call the movable middle. And this was roughly a third of the country, overwhelmingly female. They told pollsters almost unanimously that they knew somebody who was, they had a friend, coworker, or family member who's gay or lesbian, and they supported civil unions. And these people had become convinced, had been persuaded by a decade of these arguments that gay couples deserved hospital visitation rights, that they deserve the ability to pass property on to a surviving spouse, that they, all those things, but they had not. What they did not fully get was why gay people wanted to get married, because they got all the rights and benefits through that system. So I support that. And then I don't have to reckon with the kind of religious moral questions about marriage. And so to some extent, the civil unions movement had been so inadvertently successful that the people that these campaigns in 2010, 2012 were persuading were not people who were opposed to recognizing gay couples. They were people who you had to convince civil unions are not enough. And civil unions are insufficient. And so you had to go back to these people. And basically the messaging challenge was, we have to explain to these people why gay people want to get married.
Right.
And the argument is that they want to get married for the same reason that everybody else wants to get married. But they had not been told that, because they had been told that it's about visiting somebody in the hospital. And so it's, it was a challenge. And all of a sudden what you start to see is things like putting gay couples in TV ads, which had been basically verboten. And if you think about who you're persuading as people who are fundamentally anti-gay, you would get why that's not a great messaging tactic.
Right.
Think about, I'm trying to get people who already are sympathetic to civil unions to make the jump to supporting marriage. You would get, oh, okay, I need to show them what gay people being married looks like, and that it's you can identify with it. It's non-threatening. It's, all these things. And so that's the big shift is that the audience has changed.
And that's right. And that there's also the sense, I found this personally, we had a ceremony in 1999. Obviously it's not legal, but the number of people who were at that ceremony who are very smart, well-educated people had no idea that this was not actually a legally sanctioned event, or that we had to set up an entire legal model structure to do all the things that marriage gives you, right? It was oh, I thought this was all done now. we've sort of gotten to this next place. People are getting married. I know these gay couples. And so it seems like there was as much too about getting people who were supportive of this idea of gay couples having a marriage, that actually this is not, we need to go a step farther, right? That it's not just trying the persuadable middle, but even those who were supportive of it didn't quite appreciate or understand that this wasn't a done deal, even though there was will and grace and people seem to be more accepting of this issue, right?
Yeah, you know, and I think there was an effort for many years among gay marriage campaigners saying this is just civil marriage, like,
right.
You know,
it's not going to hurt your marriage. Don't
worry, your marriage. It's not going to
hurt
your religious denomination. It's not, and I think some of that, in effect, was to minimize the symbolic value of being married, fully married, not just at a holy union ceremony or whatever, and we got contracts, but that like being validated, respected by the institutions of society could come along only with marriage. And you know, and part of it, this picks up the other storyline that we left behind, which is like the divisions within the gay rights community, the gay and lesbian community over marriage really shifted. There's still people who are critical of marriage as an institution. I mean, there's straight people who are critical of marriage as an institution. But what became, you know, I think in a way that wasn't clear was going to be the case in the 1990s, it became clear by a decade ago that that pursuing marriage as the kind of, you know, the gold standard of relationship recognition was important to people, and that the sort of full inclusion in the American family would require being able to get married on equal terms. And I don't think that was clearly stated as a kind of, not just an ambition of like political and legal leaders in the LGBT community in the 90s, but necessarily by you know, rank and file gay people, because gay folks of a certain generation just came up not expecting that marriage was an option and perhaps not structuring their lives around that as a goal. And I think what you started to see, you know, and I think that marriage just becoming a political and cultural issue in the 90s in the way that it did, you know, a lot of the story is about like breaking down a barrier of imagination. Like,
right.
It was crazy in the early 1990s to think not just that gay and lesbian people could get married in your lifetime, but that this that was just nuts that you should demand it or expect it or fight over it. And so you started to have a generation of gay and lesbian people who treated this as a real, even if they weren't in states where it was legal, they could imagine, I have an ambition of getting married. And that was not somebody who had that ambition in 1990 was like bonkers. And so I do think that that's part of it, is you had a kind of demand side within the gay and lesbian community gin up out of, in response to the sort of, you know, salience of this as an issue.
The other thing I want you to touch upon is the way in which conservatives, those who didn't like the idea of gay marriage, really used the issue of it being, you know, about freedom, right? And sort of a freedom from having your children have to learn about such things, right? That, and look, we still see this today, certainly, or most especially now on transgender issues, but this issue of, look, you guys can do whatever you want, you're adults, that's totally fine. But when it comes to, oh my gosh, now my kid, my little kindergartner is going to have to learn about what gay marriage is, and then I have to explain to them what a gay relationship is. Well, that puts a burden on me. And that was a pretty effective line of attack for many years. Talk about that and how it became sort of diffused by the pro-marriage movement.
Yeah, and so I think this is another thing where the kind of political rhetoric is downstream from the legal arguments.
Mm-hmm.
You know, Hawaii was the first place where a state had to go and defend discrimination in its marriage laws in a trial in 1996. And initially, the state attorney general said that, you know, we have 7 possible rationales that we're going to put forward in court for why it's okay to discriminate. And you had stuff like moral disapproval, and it's the best model of the family, and like some crazy things like would be bad for Hawaii's tourism industry, which I never really understood, but whatever. And over a series of legal cases, and notably trials that took place in Hawaii in 1996, and then in federal court in California, the Prop 8 trial that David Boies and Ted Olson, where they sued the state. Courts dismissed almost all of these arguments. And especially after the Supreme Court ruled in the 2003 case that, in the 1996 case, the 2003 case, you couldn't just ban gay sex because of moral disapproval. Like, that was not a justification for having a law. It threw out a lot of the kind of moral and religiously informed arguments about, or just general ideas of superiority of heterosexual relationships, or the inherent inferiority of homosexual relationships. And so much of the political rhetoric was founded upon this idea that they were just like fundamentally inferior. And those got laughed out of court because they just couldn't, they had to put witnesses into courtrooms to demonstrate this, like have social science or like something that proved it, other than basically citing like the Bible and 6,000 years of human history. And they could put nothing in front of a judge. And the judges were contemptuous of the arguments that were made. And I think that the last argument that was standing in court was this question about whether children are better off if they're raised in same-sex households or in opposite-sex households versus same-sex households. And the most generous reading of the research that was marshaled behind this is maybe it's too early to tell. There's no actual evidence that kids are worse off, but there was enough like we're not really sure, and it sounds like it could get really bad if we don't know. But what I think over the course of focusing the legal arguments on the kind of kids related stuff, they realized how potent this was as a political issue. And what you had was this real imbalance. You look at the ads from Prop 8 and you have this, some version of either they're going to, try to turn your kid gay in school, or as you say, Amy, like you're going to have to explain this stuff to them because they hear it in school. And then on the other side, literally the closing out is Dianne Feinstein in her home library saying, don't mess with our Constitution. And you had this incredibly emotionally potent, scary stuff, and this incredibly inert, legalistic, constitutional on the other side. And anybody would just look at those two ads and go like, wow, these are hitting different registers. And so part of what happens just is that the messaging around marriage gets this emotional component because you're saying like, gay people are invested in being married for the same reasons you are. But then also they have a community of interest around people, families, coworkers, children who are invested in them being married. So much of Anthony Kennedy's decision in Obergefell is about the fundamental constituency that he's talking about is not entirely the gays and lesbians are punished by being excluded from marriage, but the children that they raise are being basically branded with a mark of inferiority because their parents are treated as lesser in the eyes of the law. And I think that, that is downstream from a type of emotional political messaging that you started to see a shift towards. And there's just such ambivalence early on. Anybody who went into one of these campaigns to fight back a gay marriage ban said, let's run ads of lesbian parents with their kid would have said, no, that violates every rule about what is going to scare off moderates. They don't want to see a gay and lesbian couple together. They talk about the ick factor. It's going to gross people out. And then you don't want to show children because it just makes people, and like, I think that there was this, we need to show gay and lesbians as they live and in their communities and all this stuff. And that's a big term, I think.
I want to go to one of the questions here that I saw come up, and it was sort of a it now comes into here of a what comes next, right? The next big hurdle. And I just want to read. I noted this. You noted this too in your postscript about Gorsuch writing. I think this is in Obergefell, right? This is his opinion in Obergefell about express. Oh, Kennedy. Well,
or Gorsuch wasn't on the court during.
That's right. So it couldn't be that. I don't know where, but this is your line. Gorsuch expressed sympathy for the concerns of those who held religious beliefs and were upset by these rulings, but instructed them to prepare lawsuits that would invite the court to rule on, quote, how these doctrines protecting religious liberty interact with the newly expanded civil rights protections. So it seems like that's sort of where, and you said, and this is, you said with that invitation, the Supreme Court seemed to close the book on one era of gay rights jurisprudence and open the next. So can you explain that and to our questioner sort of where things go next? Right?
Yeah, I think that was from the Masterpiece Cake Shop, which was a baker in Colorado.
Thank you. Yes.
Who a couple had been married in Massachusetts, wanted to get a cake for their two men, get a cake for their wedding. And the baker said that it sort of violated his religious beliefs to make a cake. And then there are a whole lot of things about whether baking a cake is a form of personal expression. But it showed sort of how much the tide had turned. We had for 40 years, religious conservatives arguing in the political sphere that they represented a Judeo-Christian majority. And there's a reason that Jerry Falwell's group is called Moral Majority. The idea is that there's a Judeo-Christian majority in this country and that the laws should reflect those values. And this drove a lot of the abortion messaging. It drove the idea that we should amend the Constitution to reflect this traditional Judeo-Christian view of marriage. And what you started to see, even before the Supreme Court ruled in Obergefell, was conservatives saying, we lost the culture wars. Defeat is inevitable, and we're now the victims. We're now a persecuted minority that needs the protections of the court because we cannot win in the political sphere. The media, Hollywood, academia, the political establishment is systematically structured against us. We need to be treated as a protected minority under civil rights, civil liberties laws. And it was exactly the same posture that gays and lesbians and other minority groups took when they would go to courts and say, yeah, we lost in the political sphere. It's fundamentally biased against us. We're powerless. We're a powerless minority. You need to protect us. And so what we're now seeing is, this is fundamentally the kind of jurisprudence of the defeated. They've given up on, at least on the sort of gay marriage relationships front, trying to define the law as they see fit. And now they want basically to be protected from having to be forced into this activity that they don't like. I think that, and so that I think is just a response to losing, is saying we need to be sort of sheltered from the state forcing us, into this. And I think the legal question is, how far can that be taken? I think that, there's a case that the court will rule on presumably later this month called Fulton versus City of Philadelphia, which is about a Catholic social services charity and whether they can refuse to place foster children in with same-sex couples. Could we end up in a place, and I think a lot of people expect that the court will rule that is an unfair imposition on their First Amendment religious liberty rights. But then I think you could have a question, could, let's say, Hobby Lobby, a private company, decide we're not going to give dental coverage to couples who are in same-sex marriages. We'll only give it to people who are in opposite-sex marriages. And how big is the carve-out? And will that end up having the effect of, yes, there is civil marriage and everybody is married in the eyes of the law, but the court has given wide berth to the private sector to say, we could just treat different types of married couples differently because of our religious beliefs. And so I think that's where the sort of fight on marriage is. And I think the trans stuff is, an example of religious conservatives going where public opinion is still in their favor, and where still the kind of innate status quo bias of this thing is new and foreign and people are uncertain and scared about it. And if we're protecting the status quo, we're in a much better position than trying to undo the status quo.
Sasha, I want to throw this back to Julia at Politics and Prose for a minute and see, because we're coming to the end here. And Julia, are there any other questions from the audience that you can put out to Sasha?
We are nearing the end of our time. So just quickly, do either of you have a copy of the book that you can hold up for our audience out there?
Yes, good job. I'm the kind of person that takes the cover off mine, so it's terrible. I'm not good for pitching it, but
I really, too, since we're ending the time, like the notion of leaving it to the what's next big picture question.
Yeah.
So we merely at Politics in Prose want to thank both of you for being here and encourage folks at home to follow the link in the chat to get their own gorgeous copy of The Engagement, America's Quarter-Century Struggle Over Same-Sex Marriage from us at Politics in Prose. Really, your patronage and dedication enable us to bring you this incredible programming, and we couldn't do it without the book sales to support it. So please go ahead and follow the link in the chat, or you can visit us at politics-prose.com. And while you're there, feel free to check out our events calendar for everything else coming up from us. And from our shelves to yours, we hope you're out there staying strong, staying safe, and staying well read. We will see you next time. Thanks again, Sasha Issenberg, Amy Walter. Have a good evening.